Good evening, everybody. Thank you very much for joining us tonight. My name is Win Everts, and I'm the Executive Director of the ARC Connecticut. And we're really happy to have so many join us for this presentation about understanding ABLE accounts. Before we get going, I just wanted to sort of map out what the evening is going to look like. After these beginning remarks and after introducing the two speakers, they're going to speak for a while, and then there'll be a question and answer period. Please write your questions in the chat space, which you can find by moving your cursor to the bottom of the screen. And then we will go through those questions, as many as time allows before the 7:30 cutoff. Okay? We're thrilled tonight to have two people that know an awful lot about this subject. Our presenters tonight are Andrew Komarow. His personal experience as an individual with autism spectrum disorder inspired him to create planning across the spectrum, to specifically work with individuals, families, and care teams of those with special needs. Andrew is a certified financial planner, a behavioral financial advisor, and a chartered special needs consultant, among many other designations. He's joined tonight by Steve Rubin. He's earned the distinction of being a certified elder law attorney from the National Elder Law Foundation. Steve's passion for helping people with disabilities stems from the fact that he knows what it's like to sit on the other side of the desk. Through his personal experience in taking care of his family members, he was thrust into a number of roles that his clients often find themselves in: caregiver, advocate, provider, and certainly a concerned loved one. So with no further delay, I'm going to turn it over to Andrew and Steve. Thank you very much for joining us, gentlemen.
Thank you for having us.
Thank you very much for having us.
I think everybody can see your presentation now, so take it away.
Perfect.
So this ABLE account presentation, we've done a few of them. In regards to everything that there's been a lot more interest, especially with the stimulus checks and some unemployment money. So definitely seen a lot more questions about ABLE accounts recently. We don't start by talking about ABLE accounts because it's really important to know why you're doing something. Nobody walks into my office and says, I need exactly this type of trust, right? If you're looking to an ABLE account, generally, why are you opening an ABLE account? And one of the main reasons is in order to qualify or to stay qualified for benefits. So we start off the presentation by doing just a brief overview of what some of those benefits might be as a reason to open an ABLE account. Then we will talk about ABLE accounts and special needs trusts, because they're very similar in lots of ways and there are some differences. Definitely encourage questions along the way. So if a question pops up, the moderator, Win, if you're reading them, if you want to interrupt Steve or myself along the way, I definitely encourage that. Get a little back and forth with some questions and try to make it, at least slightly a little entertaining, as much as it can be. So, and actually, we also have some very exciting news on ABLE accounts that hasn't been announced yet, that I'll share in a bit.
So the first part of this is talking about, government benefit programs and where the benefits are really coming from. The most common program we hear about is Social Security insurance. Social Security SSI is basically the most popular program for people who are 18 and have no work history. And generally speaking, for SSI purposes, it's a national standard for disability and it's a national payout number. So this year it's $783 a month. SSDI is one that's going to pay slightly greater amount. And then there's also a disabled adult child rule through SSDI that we're going to talk about. Then for medical side, you're generally going to deal with Medicaid or Medicare. Those are generally going to be the primary insurances. And then there's different housing support programs out there now. There's newer rules for Section 8 and group home living. Some of these rules are going to be very interesting to see where these things go as a result of COVID and how some of the funding is going to change as a result of COVID. I'm very curious to see how they balance the budget in both Connecticut and federally to deal with some of these things, and if they're going to realize, hey, these programs actually have a benefit and maybe we should fund them a little bit more because they were really useful during the COVID crisis. So SSI in general is designed to pay an individual regardless of their work history. It doesn't matter about their whether or not they've ever had a job at all. As long as someone is disabled, they can become eligible for SSI. Whereas SSDI is generally based off of work history. So it's what we call the 40 quarters rule. 40 quarters basically means an individual has worked 5 of the last 10 years prior to the date of their application or the onset of the disability. SSI is a means-tested program. This is one of the big things to know about with SSI. So to qualify under federal law for SSI, you have to have less than $2,000 in assets. Now, in the majority of states, that is the same rule to then qualify for Medicaid, and you'll automatically qualify. But you live in Connecticut, and we're special. And as a result of being special, we are a 209B state. And a 209B state means that prior to the enactment of the federal law announcing all of SSI, the state of Connecticut actually had its own rules, and so did a number of other states. So when they created the SSI program, the federal government said, we want to respect states' rights. We're going to allow those states to keep some of their own rules. As a result, Connecticut's income and asset rules are different than the federal ones. So for Medicaid in Connecticut, you're only allowed $1,600 in assets, not to the $2,000 that the federal SSI rules state. As a result, you don't automatically qualify for Medicaid in Connecticut just because you have SSI. You have to apply separately for the Medicaid program and go through the asset test all over again. The only fun part about that is the state of Connecticut will take the SSI determination of disability in most cases. They don't make you go through a second test, although theoretically they can. But it is a little bit of the Connecticut two-step, we call it. So almost every other state's one step to just get on the program. Connecticut, you have 2. Now, for most people, we don't recommend that they apply for Medicaid or SSI benefits generally until the child reaches the age of 18. The reason we don't have someone apply for SSI until they have reached the age of 18 is because of the federal Deeming statute. So the Deeming statute says that the parent's assets or the parent's income are deemed to that child. So if you have a parent who's earning any income at all, that child is then treated as if they're earning a portion of that income as well. If the parent has assets, including retirement accounts, those assets are deemed to that child, so they're not going to qualify. So we want to avoid the Deeming statute. So unless it's a very rare situation, we don't have anyone apply until they're 18 years old. One big thing to note with Medicaid and SSI, and in general, it's really an SSI issue, is that SSI benefits can be reduced in a lot of situations. It's very common to hear like the 1/3 reduction where someone has been employed part-time and they've had their benefits reduced. But one very common area of reduction is called the in-kind support and maintenance rule. In-kind support and maintenance is basically when you give something to someone who's receiving SSI benefits that can be used for food and shelter allowances. And the administration has actually provided us with some really good examples. One of my all-time favorites has been the airline ticket rule. If you give a child a refundable airline ticket, they can theoretically sell it and return it for something that they could turn into food or shelter. Therefore, that would be deemed in-kind support and maintenance, and they'll have their benefits reduced by 1/3. If, on the other hand, you give them an airline ticket that is non-refundable, they can't sell it on the market. They can't turn it into support and maintenance because they can't buy food and they can't have shelter with it. Therefore, it will not reduce their benefits. So the administration is very strict about these things. And anything that is used or bought and owned by that person has to be for their sole benefit. And there's another couple of really good ones that I'll talk about as we go. SSI generally goes to Medicaid. SSDI usually is a Medicare-based program. Most people who get SSDI will qualify for Medicare within 2 years unless they meet a hardship, in which case certain hardships are based on compassionate allowances will automatically qualify someone for benefits. The most common one is something like ALS, where someone's going to be sick and we don't want to wait 2 years to give them coverages. There's no asset test for SSDI. You can have $1 million and still qualify for it. However, there are some income limits, so you can't have full income coming in. There's no reduction for the in-kind support and maintenance. Now, one of the really nice things about the SSDI program is that there's a disabled child rule. And the disabled child rule says if someone was diagnosed with a disability prior to turning the age of 21, they can qualify for the disability under the parent's work history when that parent either retires, becomes disabled themselves, or dies. So they can actually collect under the parent's work history. And it's very common to see someone go from SSI to SSDI automatically, where there's a very quick switch over from Social Security, and all of a sudden their check jumps way up, and it can disqualify them for other benefits because now all of a sudden they lose their Medicaid because they're over the income caps. Now, most people don't care about how the programs are funded, but we put a slide in here for those of for the few people that actually care. But in general, the big thing with the programs is how they're funded. Is usually SSDI is generally going to be funded by an earnings record where employers and employees pay into the program. And SSI is generally funded by federal and state supplements. So in determining like which coverage someone wants, which one's right for them, the answer is, doesn't really necessarily one or the other. Sometimes it's both. The big thing is always to figure out what are we eligible for, what are we trying to accomplish, and that generally is going to be the determining factor in what program we're really pushing for. If someone's not on SSDI, obviously Medicare is automatically out, but you can be on Medicare and be dually eligible for Medicaid, and Medicaid is kind of a gateway to a lot of additional programs, so we always want to be evaluating, should we go through those extra steps to get on Medicaid? Whereas SSDI may not have an asset test, we know Medicaid does. So we want to put all of this together, and that's why this isn't necessarily a vacuum decision, but it's a time and place, and it's part of an overall bigger plan.
And just to comment on the Medicare, Medicaid, extremely simply, right? So SSDI is Medicare, SSI is Medicaid. One important thing to be aware of, though, is there are instances where you could be eligible for SSI and SSDI, and you get one check that's both. So one thing that's really important is in Connecticut, there are 32 different benefit programs with 32 different sets of eligibility criteria. So instead of trying to have them all memorized and figured out, you want to look at the lowest common denominator. So if it's 1,600 versus 2,000, you want to just go with the lowest common, just do 1,600. I saw a question pop up on the screen. Medicaid is by the states, so we call it Husky in Connecticut. And the two primary Husky that are relevant, Husky C and Husky D. There's differences between both of them. In order to be eligible for DDS services, Husky C is the gateway to those. So as a general rule, we're usually talking about Husky C. And I say as a general rule because every situation's very different. So when you hear Husky, there's many different types of Husky. So, and
Husky is not Medicare, because Husky and Medicare are two very different programs. I also saw a question pop in. What is SSA? SSA is the Social Security Administration.
So
and
what
yes,
isn't? Oh, sorry.
Oh, and the last question I did see that came in is, do you have to apply for SSDI or does it happen automatically? Yes, you have to apply for SSDI benefits. Nothing happens automatically unless you're already in SSI. And then a lot of times if a parent dies, they will automatically convert the person over to SSDI. Otherwise, you always have to apply.
On the working disabled, that's under Husky C. The asset limit is 10,000. I saw that as a question, and the retirement account is unlimited. It's a great program that's unique to Connecticut. That is something to also keep in mind is Medicaid Husky, the rules are specific in Connecticut and they vary state by state. So, for example, we do analysis of somebody's looking to leave Connecticut. I don't get too many of people looking to move to Connecticut. And they're curious the benefits here versus state they're considering. So that's something to keep in mind as well. Also, before I mention what is an ABLE account, I want to share that although Connecticut does not have one, and we've been talking about it quite a bit, Connecticut did release a request for proposal to have their own ABLE account, and they did select the provider for the ABLE account. There's something called an ABLE Alliance, which is roughly about 20 states pool their resources, so Connecticut doesn't have to build it from scratch. So Connecticut will be part of the ABLE Alliance. Given that this law is 6+ years old and we still don't have the ABLE account yet, although I'll say this is extremely positive news, there is no reason to delay and wait for Connecticut to open one. When Connecticut does, if the Connecticut one makes more sense, you are welcome to move from another state into Connecticut. But I wanted to announce that on this webinar, and I don't even think anything's been announced by the state yet, but we are actually moving in the right direction, even in the midst of COVID-19. We have selected an ABLE account provider. Okay. What is an ABLE account? An ABLE account, the government likes coming up with nice acronyms, achieving a better life experience. It's also part of the 529 regulation, so that's why you see the image on the right. An ABLE account is actually also called a 529A. That's why each state has their own one. It is modeled similarly after the college savings law. So 529A is an ABLE account, and that's also why every state has their own individually. In Connecticut, we call it CHET. That is our college savings available to us in Connecticut. So why might an ABLE account be necessary? So income from an ABLE account. So you're able to shield money inside an ABLE account from not being counted towards that $1,600 limit. And again, I'm using $1,600. As mentioned, there were some programs, everything changes different, but you're able to shield that from the benefit programs. So if they say you can only have $1,600 and you have $10,000 in an ABLE account, that is hidden, that is not counted. That money also grows tax-free, and you are able to take the money out and you're able to spend it on qualified disability expenses. What is a qualified disability expense? So this is a short list of what is a qualified disability expense. I want to encourage people that the government's being generous here. They're vague on purpose. It's not as strict as the sole benefit, such as Social Security. So if you can think of a justification to use the money for an ABLE account, I would say that that is pretty good. I've only ran into one instance where I didn't think it was necessarily appropriate, and that was a nonprofit was asking if they could use the money in the individual's ABLE account for a gazebo. And what I would say is, well, that's not really just for the individual, even though he might use it. If it was a ramp, so the individual could use the gazebo, but the gazebo was really more for the nonprofit, for everyone else. It really wasn't specifically for the individual. If you want to send an example to try and stump me, feel free to put them in the comments. But if you can justify it, it's a disability expense. Keep records, but don't, this seems to be something that's more encouraged and very liberal. And I encourage people not to get too hung up on, is it a qualified disability expense? It almost certainly is. Vacations, yes, again, those can all be justified. Support dog, 100%, absolutely, $1,000,000%. You know, upgrading the house, again, if it's for, think of the gazebo example, you can use an ABLE account to buy a house, right? So very, very liberal. If you want to email me after and try to stump me, you can, but for the most part, it's you should be able to use it. The answer is yes to all of these. Steve?
So the question was, you know, horseback riding, gym membership, or swimming, is that considered a medical expense? Yeah.
Equine therapy is,
Yeah,
you know,
it's
is it-
absolutely a
yeah.
valid medical expense.
We're going to get all of these things you're asking. Yep.
Yep. Speech,
Well,
language, OT, PTA, yes, those are all valid expenses to use an ABLE account.
The answer is yes to all of these. Again, my point is that very liberal. If you can make a justification, right, then you should be okay. Who is eligible? An individual with significant disability. So what that means is the Social Security definition of disability. That does not mean you need to be on Social Security or Social Security disability. You need a physician to sign a letter saying you meet the criteria. Additionally, the onset of the disability has to occur prior to age 26. That does not mean that it needs to be open prior to 26. That also does not mean that you have to be on SSI or SSDI prior to 26. For example, I have an ABLE account for myself. I was diagnosed with autism at age 28, but because I had autism prior to age 26, I am eligible to open an ABLE account. If you are on SSI or SSDI, then you are automatically eligible. Otherwise, just a simple letter from a physician when you open the account. I have a sample letter, but really anything confirming the disability from a doctor should be satisfied. Next slide. So there's some nice tax benefits when it comes to an ABLE account. They're very similar to the tax benefits for college savings 529 plans. One thing to note is that although the money does grow tax-free and nobody likes paying taxes, it is important to note that that's not the main reason to open an ABLE account. Because if you get to a certain limit over $100,000, then that money is not shielded from SSI, Medicaid anymore. So an ABLE account as a general rule is not going to be an asset where you can accumulate, you know, as much money as a 401k, or you might want to. One important thing is if the individual who has the ABLE account is not a dependent, there is something called the Savers Credit, which is a tax credit from the federal government for individuals with lower income to contribute to a retirement plan like an IRA. So, for example, if the person got a $1,200 stimulus check, means they weren't claimed as a dependent, generally, and it's worth checking to see if they would qualify for the Savers Credit. Think of it like a match from the government for putting money into an ABLE account. With an ABLE account, in some states, there is a state tax deduction. Connecticut does not have a state tax deduction for an ABLE account because we don't have an ABLE account. Now, you are able to do something I call the Chet Shuffle, which is you can put money in Connecticut's Chet and move it into an ABLE account right away in order to get that tax deduction. If that is, of interest and important to you, it's $10,000 a year if you're married, max deduction from the state of Connecticut. So that is important to be aware of. You are also only eligible for one ABLE account. So grandparents, parents, they can't have two separate ABLE accounts for the individual. Only one can be open at a time.
Andrew, if someone has a 529 account that was set up for college funding, can they transfer or roll it into an ABLE?
Absolutely. Next slide. Skip that one. So with the 529, recent tax law did allow to permit to move from a 529 to a 529A. However, it's still subject to the limit. And the limit, generally speaking, is $15,000 a year you are eligible to put into an ABLE account. That also applies to money coming from a traditional college savings account of 529. The limit is higher, closer to $26,000 if the individual is working and they're not contributing to a retirement plan. Connecticut does not have an ABLE account themselves, but you are able to pick from the 42 other states that do. So, and even when we do have an ABLE account, think of it as just you have choices. So there's, and I'll go over a couple of the states that have some benefits and features that are a little bit different. And when Connecticut has theirs, if it happens to be better, you can consider it. I'm encouraging people, do not wait for Connecticut to have their own ABLE account in order for you to open one. There's no reason to delay. And if Connecticut makes sense, then you are able to move from whatever state you chose into Connecticut. So this is options for opening an ABLE account. I'm oversimplifying. Out of all of the options there, I think it's also important to not get bogged down by, the states and what they offer. There are some small differences between them, but it goes back to what are you looking to accomplish? What are you looking to do? And I find that it comes down to, I recommend 2 states generally, depending on the situation. And on the slides upcoming, I'm going to go over the pros, cons, and the link to be able to go and help open one. So will they accept money? Any way you can get them money. I think if you could get a bird to fly it to them, they'd accept it, check, direct deposit monthly. They are happy to take your money, however you can fund the ABLE account. So if you want to transfer from one state to another, that's also a relatively simple process. So for example, I have an ABLE account with Massachusetts through Fidelity. Fidelity definitely wants me to give more money to Fidelity. So they have a form you fill out and they will request the money from your old ABLE account into the new one. So the next couple slides, and then I'll answer a lot of the questions, is I'm going to recommend 2 different states for ABLE accounts and some really basic pros and cons. So I like Fidelity, Massachusetts, for a couple reasons. It's the only ABLE account open to individuals in Connecticut where you don't have a fee to open and there's no fee to maintain. For example, the low maintenance fees, for anyone who banks at Bank of America knows what I'm talking about. the $5 here and there, or the low balances. If you put in $100 and you get a $35 fee, it's not really that helpful. So Fidelity is currently the only one without a maintenance fee. No minimum, or if it is, it's $25 or something. And there's also no fee to have a debit card or take the money out. The cons are it's a little bit harder to spend the money. So Fidelity simply just has a two-step process. You can't just use a debit card to take money out of the ABLE account. You should look at it as essentially moving money from a savings account to a checking account to spend it. There's no cost to doing that, but if somebody's looking to make a lot of smaller purchases, that can definitely be a hassle. And that's not Fidelity's strong suit. Fidelity ABLE accounts are Massachusetts. So, and all Fidelity only has one ABLE, and they have and they run Massachusetts. And I will provide links to the ABLE accounts I'm recommending afterwards. Ohio was the first state to have an ABLE account. They call it the stable account. And the pros are they have a great system for keeping track of expenses. I was actually hoping that Ohio would win the bid for Connecticut's. Big fan of Ohio's ABLE account. They can have a maintenance fee. And then this other con for potential dual guardianship and a debit card. It's a complicated situation where I've only run into once, but I did want to mention that as a con. The fees for the investments are a little lower, and that's because it's Vanguard passive management versus active management, which could have its own webinar in itself, but we're not going to go there today. But the fees can be a little lower for the investments, but they do have the maintenance fees. Yeah, so so Ohio, there is a fee to have it. So, and it should be waived usually, I think a $10,000 balance roughly. So that's a reason to consider Fidelity versus Ohio is they don't have any of those pesky minimum fees. These are the links to go to if you want to go online and open an ABLE account. I'm going to leave this up for a little bit and answer some questions that people might have on ABLE accounts that we just went over. Wait, if you want to moderate the questions, or I can take a look.
There we go.
There's no fee for a checking account with Massachusetts or Fidelity either. They'll give you a free checkbook and debit card. And it's pretty easy to use. They reimburse all ATM fees anywhere completely. So they're actually not even a bad bank to consider regardless.
So here's some of the questions that you haven't, the two of you haven't answered yet. Do all states allow for out-of-state applicants for ABLE accounts, or are some states closed to out-of-state applicants?
That is a great question. Some are closed to out-of-state residents. On my blog, I do have a brochure that's 2 pages on ABLE accounts in Connecticut, and I will be updating that as new things come out. I do have a comparison of a few more states than this and a few more details. I've also written an extremely nerdy, 10-page comparison of all the ABLE states that nobody on this call wants to read. I'm happy to send that to anyone. So I haven't had anybody open an ABLE account outside of one of these 2 states. One thing that I do want to mention that I did not touch on is that we'll get into it when we talk about trusts. The state can get paid back for benefits provided. Some states have a provision where you do not have to pay back the funds, such as Pennsylvania. You can't open an ABLE account in Pennsylvania to take advantage of that. So that is just a word of caution. It's the state that you live in. So.
And most of those states that have done that have basically said, we will not be paid back for anything, except there's kind of a little caveat to that of, but unless the federal law requires us to be paid back, in which case we will then collect from you. and federal law requires them to get paid back.
Can you review for some of a lot of the questions are asking basically who can contribute to the ABLE account, how much in a year, and is there a cap on the asset value of an ABLE account?
Great questions. Anybody can contribute to an ABLE account. However, only one is able to be open at a time. I think we skipped over that slide briefly. So you can only have one open, but other individuals can contribute to the ABLE account. What was the second question, Win?
Is there a cap on contributions within a year?
Generally, it's $15,000 a year, unless the individual's working and not contributing to a retirement plan, then it's closer to 26,000. I will send to Win a copy of our one-page PDF that has a lot of all these quick facts on it, specifically to Connecticut, that he can send out to everyone on the call to reference as well. Yep.
And then the final part of that question was, is there a cap on the amount of assets allowed to be residing in an ABLE account?
Yes and no. So in order to stay qualified for benefits, you need to stay under $100,000. However, states are allowed to have higher limits. I believe it's Michigan that you can technically have 500,000 in an ABLE account. I've only run into one situation ever where that might make sense, but if you have that much money in an ABLE account, it's not helping shield the money for benefits. So I think Michigan, if you want to put $500,000 in an ABLE account, that's the place to go.
Okay, now we're going to change the focus a little bit. Who is the actual owner of the ABLE account?
Steve, can you go back to that slide? So the owner can be the individual, right? The owner can be a parent. The owner can be a guardian. So there are options for who can have the ABLE account, who can be the owner. But again, keep in mind, you're only eligible for one. So it can be established by an agent, durable power of attorney, legal guardian, parent, or beneficiary. So that would be the individual themselves with the disability.
Okay. If there are two parents and they are no longer married, can one of them that's not the guardian set up an ABLE account?
If the individual is over 18?
Yes.
So then, no, they're not. Steve?
Well, the person, one who's the legal guardian can establish the account, but it does allow for any parent to establish it. So
Okay.
there's no requirement unless there's something in the divorce settlement and custody agreement that says who can do it.
Okay.
That was my
So-
thinking as well.
A question on the interaction of benefit money and ABLE accounts. If someone's receiving disability income benefits, can those benefits be deposited into an ABLE account?
Absolutely.
Yes.
And the few very common areas where we see ABLE accounts are when an individual's turning 18 and they're trying to qualify for SSI as an alternative to spending down the money, the couple $1,000s they're able to put in an ABLE account. Another great opportunity for ABLE accounts is, in light of COVID-19, not only are there stimulus checks, which you do have a year to spend before they're counted, but you can put them in an ABLE account. Also, if an individual is getting the $600 a week federal unemployment and they might be looking to go over assets, an ABLE account is a great option. So we're seeing lots more need or an interest in ABLE accounts given some of the recent stimulus bills that have been passed.
Does an ABLE account need to be started by a person, or could, for example, a nonprofit organization start an ABLE account for a beneficiary that they support?
A nonprofit absolutely can. Good question.
Okay, there's some other questions. If you're going to move on to special needs trusts, I'm going to hold up on some other questions that are asking for a contrast to that.
And that's the fun part, the best for last. So,
Always the fun.
Anything, other questions on
Yeah.
ABLE accounts?
Yeah, a couple more. If the beneficiary dies, where does the ABLE account money go?
That will be in the part where we talk about trusts.
Okay.
I see the question on rep payee. So not necessarily, and something very important to note, if a nonprofit is a rep payee and the individual got the $1,200 stimulus check, the nonprofit should be very careful and remember that that's for the individual. It's not, part of their Social Security. The nonprofit should absolutely want to make sure that money's spent for the individual or deposit it into an ABLE account. So the stimulus checks, they're deposited through the Social Security system if you have direct deposit set up. However, they're not the same. So great question on the rep pay.
Okay, and another question is, and this may be just a question about technical reporting, should ABLE account funds be reported to SSI like work income is?
Steve?
We always report it even though it's technically exempt. It's just they're going to ask about it even though it is an exempt thing. They're still reworking some of their requirements and how they're going to process all of it in the future. So for now, we just send them a copy saying, hey, this is what's in there. The reason, a big part of it is to make sure that the expenses are used appropriately, which is ironic because you can't use an ABLE account for anything that would be considered, for the most part, disqualifying for SSI purposes, with the exception of housing supports. So they can ask for records and they can ask to see what's going on with those funds. So we always just send it along.
And a really good question. What is the downside of an ABLE account?
So that's a great question. We'll get into a little bit more with the contrasts and trusts. One of the biggest downsides is that the money, has to be used for qualified disability expenses, right? Which is very liberal, but it does have to be used for them. Also, the ABLE account, the state gets paid back for benefits, has the right first. So if somebody's been getting DDS benefits and they pass away with $50,000 in an ABLE account, the state can have the first claim on those ABLE accounts in Connecticut. So that is the primary disadvantage.
Okay. Does the owner of the ABLE account have control and choice in how the account is invested?
Yes, and it's very similar if you have a 529 or a CHET. There's 6 to a dozen different investment options. One additional thing is Fidelity has a savings account. It's not FDIC insured. Ohio and some other states do have an FDIC insured option. There's a separate insurance for investments that's similar. It's called SIPC. But that is something to note. There are some small differences between the states. You are only able to change the investments twice a year. That's a law, again, similar to the college saving rule. So you can't time and, play the stock market. You have just a few investment options and you can only change them a couple times a year.
Can the extra $600 that's coming in from unemployment benefits be shielded by using an ABLE account?
Awesome question. Yes and no. So an ABLE account will hide the assets, but it won't reduce the income. There's other tools to potentially do that. But so for example, it's not like an IRA where if you put money in, you reduce your taxable income. An ABLE account can shield the money from the assets, but it can't reduce the, income requirement, if that makes sense. It helps with half of the equation.
If you have a special needs trust and the beneficiary passes away, the money from the ABLE account could go to the trust?
No, it can't go to the trust.
Thank you. How easy is it? You've recommended that people go out and start ABLE accounts without waiting on Connecticut. How easy is it to move an ABLE account from one state's plan to another?
Generally very easy. There's usually just a form and a recent statement. Who's ever going to receive the money as an investment company is usually incentivized to, get more money. I find that's usually the best customer service department, right? And the investment companies are the ones whose only job it is to help you bring the money over to them. So there's a simple form, you have a statement from the other company, and then they transfer it directly. You don't get the check directly. They just send it from one to the other. If anyone's done an IRA or a 401k rollover, it works very similarly.
Can one account be split among more than one beneficiary, or does each account need a single beneficiary?
So unlike 529, there's only one account per beneficiary, right? Allowed to be open, and it is for that person individually. You would need two ABLE accounts if there's two individuals.
Are you subject to any laws in the state where the program is domiciled? If you live in Connecticut, do their state laws say if you went to Fidelity, are you subject to any Massachusetts laws?
Generally speaking, it's the laws in Connecticut. So for example, in Pennsylvania, where they don't have a payback provision, if you opened one in Massachusetts, you would be following Pennsylvania's rules that say there's no payback provision, regardless of the state you open it in, and vice versa. So, maybe the investments themselves are subject to a Massachusetts state regulator, but for the purpose of, every normal person on the planet, not an attorney, it's the same.
But that does get to an interesting point of it is if you have a Mass account, you live in Connecticut, you then move to Florida, when you pass away, federal law says that the states actually both will get reimbursed. They'll aggregate it amongst each of the states to reimburse them. So it doesn't matter where the account is open if you have certain expenses, it matters where you live. You take the law for benefit programs based on the state in which the individual receives the benefit. So you can open the account in Pennsylvania, and be it you're getting the benefits in Connecticut, you're going to pay back the state of Connecticut. You move to Florida, which also has a payback provision, and the money in the trust is going to be split amongst those states. There's a formula based on federal law on how they're going to split it.
I saw a great question pop up before we move to the other stuff, the trust, and we should get there. And that is, now I forgot the question. So, no, what was that with?
So,
qualified taxable. If it's, so something that is not talked about too often is that if you put $10,000 in an ABLE account and you want to withdraw it for a non-qualified disability related expense, you are able to do so. You're only taxed on the earnings, and what you put in comes out first. This is the same for 529 plans and Roth IRAs. So if you put $10,000 in, the first $10,000 is a return of your money. It can be used for anything without the taxes or the penalties. Again, I'd encourage to use it for a qualified disability expense. It's the earnings that have to be used and subject to the taxes. So for example, if you have two college savings plans and you put in 10,000 and it's worth 15, you are able to take $10,000 out, spend it on whatever you want, and keep the tax deduction in the state of Connecticut. So I have clients who will put money in a 529, take it out a month later every year for the tax deduction. So
can benefits be put in an ABLE account to avoid running over the asset limits?
yes, that's the primary purpose, in my opinion, or one of the main reasons to consider opening an ABLE account. Absolutely.
Okay. I'm just looking at the clock and wondering whether
Yep.
you want to head to trusts, and because that'll probably have a lot of questions attached to that.
Yeah, I think we can go to trust now. All right, so special needs trust or supplemental needs trust, there's a number of names for these, and we're going to kind of talk about that. The most common form you'll hear of, though, is a supplemental needs trust, because the idea behind a special needs trust is that it's designed to supplement benefits, but not to supplant them and not replace any public benefits an individual might be receiving. And it actually was created and codified by the Medicaid law. So it was designed for people to receive benefits while protecting some assets. Now, one big part of this is that a lot of trusts are very dependent on state law. Each state does have their own rules and regulations in relation to trust and how they're going to operate in those states. So when someone is moving, we do have to make sure that when we're moving to another state, the trust is going to still qualify and still provide the exact same benefits that we're hoping for. Most special needs trusts are created either by a court, a family member, and finally, there's now a law that they changed the law and it allows an individual who is disabled to create their own trust as long as they are legally competent to do so. So when the trust is properly structured, it allows someone to still maintain eligibility for government benefits, similar to the idea of an ABLE account, but with some added things behind it. The biggest part of trust is kind of, the way I like to look at them, is kind of a hierarchy. So everyone, there's the hierarchy of needs. Well, there's the hierarchy of disability and special needs planning. And the top of that hierarchy is third-party trust. Third-party trust basically means other people's money. First-party trust and ABLE accounts mean it's the individual's money.
I'm going to give my short oversimplified example, and that is Steve is taking me out to dinner after this meeting, and I would very much prefer Steve to pay for dinner versus me paying for dinner. It's always better to use my friend's money than my own. So if Steve pays the bill directly, then I never got the money. However, if Steve gave me the money and then I paid the bill, well, I still had possession of the money. It's still nice that Steve paid, but it did touch my hands. So the way to think about it is it's always better to use somebody else's money than your own money. So, and that's a little bit of an oversimplification, but your own money is first party trusts and ABLE accounts are similar, and somebody else's money, third party trusts, are usually the better option when available. So, but they can always, every situation's unique. So, but get Steve to pay for your dinner, don't pay for it yourself.
Right. That's why I'm using Andrew's credit card. So self-settled trusts are basically structured in a way where it means it's the individual's money. They're also called a first-party trust. You'll hear it called a D4A trust. You'll hear it called a reimbursement trust, a payback trust. It all means the same exact thing. They're all the same names. People just decided that, we wanted to rename it 50 times because lawyers don't have enough things to do in their lives. And that's what we did. So we keep renaming it, but it basically means we're using the individual's own money to create the trust. Now, the biggest negative to that creation is what happens to that money when someone passes away. And the biggest part of that is there is a payback requirement under federal law. So federal law says that if an individual passes away with money remaining in a first-party trust, that money must be reimbursed for any medical expenses or any programs that paid out for that individual's benefit. Most states have a rule that says if they paid out money separately from the federal funds, they want to be reimbursed too. So that money, like an ABLE account, means the money is going back to the state. The third-party trust is kind of our way of preventing any payback provision. We don't want it to get to the first-party trust, and in many cases, we want to avoid the ABLE account except for smaller amounts. We want it to be in that third-party trust. The third-party trust means it's somebody else's money. So if I became disabled and Andrew passed away and he left me all his money, I'd want it to go to a third-party trust. Because in that trust, it would not count against me for benefit purposes. It could still be used for my benefit. It could buy me a house. It could buy me a car. He could buy me all the dinners I need. But when I pass away, the state of Connecticut would have no claim against that money. They could not actually go after it because there's no payback required by federal law. So we want to make sure we put things in a third-party trust. Third-party trust basically means you have to do your own planning for your disabled child because you have to basically set this up before you pass away. A really great mistake that Andrew and I found on a estate plan once was a parent who left money to a disabled child. And the will said, I give 50% of the estate to my disabled child in a special needs trust, and then the remaining part of my estate splits between my children equally outright. That would mean 25% of the assets went to that child directly who's disabled. That now makes it first-party money, not third-party money. That means that at that point in time, there could be a claim filed against that money against that child when that child passes away. So we have lost control. So the key is always to do the planning in advance to try and avoid it from ever becoming third-party or first-party money. We want it to remain third-party as long as possible. So the first-party trust can be established by an individual for their own benefit, and it has to be using their old funds. Now, they have to be disabled and meet the Social Security rules for disability in order to do so. They have to establish it prior to turning the age of 65. Federal law says it has to be under the age of 65. Connecticut does have a program for people over the age of 65. It's called a pooled trust, but in general, we want to try and avoid a lot of those creation if we can. Statutory liens must be paid before the trust is funded. So what that means is there are ways for a state to file a claim against a beneficiary's inheritance. If an individual has been receiving Medicaid benefits and their parent passes away, the state may have a lien prior to those funds even going into the first-party trust if they're named directly. So we want to avoid all that, hence the third-party trust being so important. In order to do it, we have to meet the disability rules. They essentially use a similar benefit standard that SSDI uses, which is called SAGA, which means someone's unable to have substantial and gainful activity. There's no reason for anyone to ever create one of these if they don't have a disability, so I don't know. We don't really spend a lot of time on what the word disability means because there's no actual benefit. But the key is always that payback provision. The state has to get that money, and they're very good at tracking it. It's one of the few things states do very well. I've had a number of beneficiaries pass away, and I'll get reams of paper from the state with line items of, we paid $4.25 for this prescription copay. They had a doctor's appointment on this date, and it will go back in time. We've had them go back over 30 or 40 years in some cases with every single payment that the person received to show us why they should get the amount of money back. And there's actually been substantial issues with these payback provisions and some litigation, because one of the big issues has been the payback provisions require the individual beneficiary to pay back the state prior to paying expenses. Where that runs into a giant issue is funeral expenses. If you do not prepay the funeral contract, the trust cannot pay for the funeral prior to reimbursing the state. The state gets paid back, and then you might have some money left over for the funeral, which means you should always prepay the funeral contract before we're going to get into this issue. We've also seen the issue nationally of a state where the individual passed away, but they had home caregivers, and the caregivers still were owed money. They were owed a final paycheck. And the issue became, okay, do they get their final paycheck? Can we take that out of the trust? How does that go? And the state said, no, you couldn't pay them. And they ended up in litigation for a couple of years. And eventually the court ruled in their favor that says, okay, what we're going to do is we're going to say that they can pay them back. So we really want to do all these things. We want to make sure that we're not going to have to pay back the states. And because it's federal law, it doesn't matter if it's Connecticut, if the child lives in Florida, every state gets paid back. It is a federal statutory requirement. If you ever want to look it up, I can cite it for you. But it is federal law. So we have no way around that payback other than the third-party trust. So the third-party trust really gives us a lot of benefits. The first-party trust we're mostly using in certain situations. So why are we going to use a first-party trust at all? One, Andrew has said it already, if someone has too much money in their own name, they can be disqualified from benefits if they put too much in an ABLE account. There's no such rule for a first-party trust. If there's significant amount of assets that are going to be held by the trust, or there's a significant amount of assets, a trust makes more sense because of the flexibility that it provides. One part of the flexibility is while an ABLE account funds can be used to purchase a house, a trust can actually own that house. So we want to have that, sometimes we want that flexibility in how we're going to manage it, where we don't have the same level of oversight. There's no need to do private pay for anything at that point, because we're basically doing deferred interest. And that's one of the nice things with this program and the way the federal law was worded. So if federal law says, if you owe $10,000 to the state of Connecticut gets $10,000. They don't get $10,000 plus interest. They can only charge you for the exact dollar figure that they paid out, no more. So you don't owe the state interest back on any of the money. So you're basically just kind of paying them back exactly dollar for dollar, which avoids a lot of the conflict. If there's nothing left in the trust, the state doesn't get a payback provision. The state of Connecticut's caught on to that rule in the last few years because that was a very common hedge, right? At the end of it, okay, we have some money left. Let's buy an asset in the individual's name so that the state can't really go after it. You know, we own the house jointly with the spouse all of a sudden. The state has figured that part out. And as part of the requirements, you're no longer allowed to buy real estate without the state's approval, so they say. And they want to see an accounting every 3 years on the trust assets and how it's spent. That's part of why I like third party even better, because there's no oversight by the state of Connecticut. I don't need their approval for anything. The third party trust is kind of a funnel in a lot of ways, and that's what's really great about them. Because a third party trust doesn't have to be just assets created by you. There's a number of ways to do a third-party trust. A third-party trust can be created in a will. A third-party trust can be created in a living trust, or a third-party trust can be created in its own trust. And the advantage to the funnel is kind of if you have a number of people giving distributions to someone. So I actually have this case right now where grandma and grandpa left money to 3 disabled children. Aunt and uncle who don't have kids left money to the 3 children. Mom and dad left money to their kids. The problem is grandma and grandpa did it in their estate plan. Aunt and uncle did it in their estate plan. Mom and dad did it in their estate plan. None of the plans merged together in any way. So now each of the 3 kids has 3 special needs trusts. Try doing that accounting to Social Security and get them to understand what's going on. It is going to be a lot of fun. So basically what we get to do in this situation is we create a funnel. We create one trust. Now grandma and grandpa's money goes into that trust. Mom and dad's money can go into that trust. Aunt and uncle's money. So the kids are all going to have it through one trust. They're all going to be benefit under that one agreement. And we don't have to have it set up separately. So we get a lot of flexibility by creating the third party trust that way. So because we have the flexibility of creating it, we really can do anything we want to do about how we structure these things. And that's kind of what I like doing about them is we get to have a lot of creativity. And part of the creativity and part of the control aspect of it is you get to pick who's managing your child's money for them. You pick who's going to be in charge when you're gone, who's going to pay their bills, who's responsible, and what happens to that money? Where does it go? If after that child is deceased. So third-party trust, essentially, the biggest thing is we don't have to worry about payback. We don't have to give the state their money. We don't lose benefits. We get to keep that money separate. We get to use it for the child without losing anything. And the key to a lot of these benefits in looking at children and looking at trust, because a lot of the questions I'm seeing pop in are, do I do a trust, or what's the number, or how does it work? It's got to be based on a plan. Trusts are not always or it's kind of just the document. There has to be a plan that goes along with the document. Why are we creating it? Andrew says, when you're doing an ABLE account, you have to come up with why are you doing it? Where do you want to go? Well, I'm the same philosophy. You have to have a goal. What are we trying to accomplish to figure out when we're going to set up a trust, or how is it going to work? We have to have our own planning in place in order to create a plan for a disabled individual. So we want to have a will for ourselves, maybe a trust for our own selves. Then we have to determine how the beneficiaries are going to be set up. We all need to make sure we have powers of attorney and things, because a lot of things happen if we don't have one, where we end up in a messier situation. Having our own advance directives, we always want to make sure we have those. So we want to have this as a plan. It's not just, hey, I need an ABLE account, or hey, I need a trust. It's, what is my plan? What am I trying to accomplish? Because in a lot of situations, we might have a third-party trust and an ABLE account. We've had situations where we only have an ABLE. We've had situations where we just have a third party. Each one has their own thing, and it's kind of the art of doing this that lets us put them together in a way where we can really make a plan. It's a lot more than just having an ABLE or having a document. What's the plan that goes with it? That's the part that's really important.
One example I want to use, and everyone should be thoroughly confused and overwhelmed at this point, and if you're not, then you probably weren't paying attention. But it's a lot of information, and it seems like there's lots of different documents, all these wills, power of attorneys. Think of these as parts to a computer, right? You don't say, that you have a power supply and a processor and a hard drive, right? You have a computer, and all of those pieces together, right, are the computer. And there's different parts that can be added or moved. Some can be more expensive than others. But think of the estate plan as the computer, and all of these documents as, the parts to put it together. So like we've said, it's important to have a plan to know why you're doing something. And that's way more important than what you're doing. Why do you have a trust? You should be able to at least answer that. You don't have to be able to answer, is it a D4A trust, a first party? You should know why you have it, and make sure that the people you're working with are able to implement those, essentially build the computer that you want for you.
So with that, Wynn, I think we'll open it up again to questions.
Okay, so we have quite a number of questions. Let's, I'm gonna do the trust questions first, and then I'm gonna bounce back to the ABLE questions because we didn't quite get all of them. When a beneficiary of a third-party trust passes, how is the balance handled?
So this will sound sarcastic, but it's not. The answer is what do you want it to do? Basically, when the trust is created, you can pick how those assets are going to be distributed. So you can say, I want it to go to another child, I want it to go to a charity, I want it to go to Andrew. Wherever you want it to go, you get to select how those assets go when the trust is created. If that child has children of their own, you could also say it could go to them. So you have a lot of flexibility with the distribution after the child passes.
Can the state attack or attach a special needs trust that a parent sets up for a disabled child?
So a third-party trust is very difficult for the state to attack. I mean, there are methods in which they've tried to attack them, but a properly drafted third-party trust, it's really impossible for them to win because the trust is very clear on its face. This is what it's designed to do. This is what it's doing. The biggest negative I see to trust is the trust and wills are the easiest ones for there to be issues with. And the reason why I don't like trust and wills that often is accounting to the court. one of the things with a trust and a will is generally you're going to provide a lot of accountings to the court, and those are public hearings. People have a right to come in. There is a right to public situations. I mean, I've actually had a case where the beneficiary of a first party trust that was created, and the judge said we couldn't seal the hearing because the public has a right to know, and we have a statute that says that. So the first party trust and third party trust being done outside of this is generally going to be a better method of doing it, because we want to have a little privacy. A beneficiary should have a right to privacy. So I'm not worried about them attacking it all the time versus other people also knowing the information.
Can a third-party trust roll into an ABLE account?
There's no reason for there to ever happen. A third-party trust has no payback provision, an ABLE account does. So the only reason you'd be doing that is if you wanted to pay the government money it's not entitled to.
Great answer. Do trusts pay taxes, like on earned income?
Trusts do pay taxes based off of income that is earned, but it is on earned income. So if the principal is in the trust, the principal doesn't have income taxes attached to it. It's only on the income that's earned. Trusts themselves generally pay taxes at a higher bracket than an individual because the brackets for trust are more condensed. However, when you do a lot of these things, the biggest thing with a trust is that the trust also gets a deduction every time it makes a distribution to the beneficiary. So the beneficiary is really the one who's going to pay the taxes on any of the money that they receive, which is what we want because they'll pay at their bracket, which in most cases is almost zero.
So I'm going to ask the question, is there a magic number that needs to be reached as an asset level in order to establish a special needs trust?
For a third-party trust, it basically means that there's going to be money going to that child. At that point, there's no magic figure. I've seen them set up for very small dollar figures and for a lot larger ones. It really depends on where is the money coming from. You know, if it's coming from you, do you want that money set aside for that child without the state being able to grab it when that person passes? Then it's worth setting it up. I've seen them set up for as little as 5,000. So no, there's not really a magic number for a third-party trust. A first-party trust, it generally depends on what type of benefits we're looking at and what the long-term plan is. There's no, again, not really a magic figure. It goes back to the plan because first-party trusts do have some advantages over ABLE accounts, like income reduction if money is transferred to a first-party trust for certain benefit programs. So it's going to be a balancing act.
What does it cost to set up a third-party trust?
It varies depending on the part of the plan. You know, they're not going to be a couple $100. They're usually going to be in the couple thousand range, but it's going to vary depending on the type of setup that it's going into it, the terms, and how it's structured.
Has Connecticut gotten more aggressive in going after special needs trust money as a matter of course? Are they closely
I haven't
monitored?
seen them get that much more aggressive for the most part. There are certain exceptions. On first party trust, if they really dislike the language, I have seen them go after them. I haven't seen them get more aggressive on third party money. First party money, they tend to be a little bit more aggressive in how they're handling it, how they want the trust to be structured. So that's another advantage to the third party over the first party is you don't have to deal with the Attorney General's office.
Can a third-party trust transfer $15,000 a year into an ABLE account?
Technically, yes, but you should never do that.
Yeah, there's no benefit at all.
Correct.
Because of the payback.
Correct. The only example I've ran into it once, and but let's just go with your. That's not something that you would want to do.
Yeah, it's a bad idea. It's such a rare example. I don't even want to get into it. It's never a good idea.
Okay. So what happens if a child has the third-party trust set up for them and a grandparent dies, naming the child, not the trust, as a beneficiary?
So that's a great question, and that's one of my big concerns and why the whole plan has to work together. When the grandparent names that child directly, that trust money becomes first party. As soon as that child is the beneficiary, it's a first-party fund. You can no longer convert it to third-party money, even though the grandparent probably intended for that to be the plan. There's a slight exception to that, and the exception is if you can get a court to order the money into a third-party trust and say that was their actual intent and it was a drafting error on the part of the attorney who did it, but that's really hard to prove. So you always want to make sure it's going to that trust. One of the things we always encourage is a family meeting after the trust is created to say, if anyone has the intention of doing it, this is the name of the trust, this is where the money needs to go.
Can you deposit extraordinary income things like these stimulus payments into a special needs trust, a third-party trust?
Not into a third-party trust, because that would be if they're getting the payment, it's first-party money. So that could go into a first-party trust or an ABLE account, not a third-party trust, because then you'd convert the trust over to first-party money. You'd poison the well.
For a special needs third-party trust, when the funds aren't deposited until the death of parents, because their funds are coming from a life insurance policy, how does that money get invested?
Once it's in the trust?
I assume so.
Well, so once the money is in the trust, the trustee has a fiduciary duty to follow what we call the Prudent Investor Act, which basically means they should meet with a financial planner and discuss an investment strategy. So, I mean, there's all different strategies depending on what the goal is. Some are income-based goals. Some goals are, we don't need a lot of that funds right now, so we want it to grow. We want the principal to grow significantly. And other ones, we need to do distributions more frequently, so we have an income-based goal. So that's where the team of having an attorney and a financial planner on the team is really important.
And you can help lay out those options, in advance. You can have, let's say there's trust companies who can manage some of the accountings, the distributions, or the investment manager. You can, get a lot of that set up for the person and the instructions. You can also make the trust only invest in certain things. As a general rule, like to keep flexibility. The more flexibility, the better. So you can have real estate in a trust, but you could also draft a trust where you can't have real estate in a trust. Generally speaking, you want to give the trustee the discretion to do what makes the most sense at the time, because we can't predict the future. So generally, I recommend that you just have as much flexibility in your plan as possible, because things change all the time. That's something to keep in mind.
Exactly. When we draft a trust, our design is if you're trusting that person to be able to make decisions, we generally don't want to handcuff them on their investment strategy, because I can't predict what investments are going to look like 10 years from now. So why would I handcuff someone and say, you can't invest in something that 10 years from now turns out to be the best investment possible? So we want to build that flexibility in.
Next question is, can ABLE accounts, and I'm going to add a special needs trust, affect a DDS individual's eligibility of moving into a group home or an ICF residence? Do they affect your Medicaid eligibility?
In a positive way, done correctly, they should help you get Medicaid eligibility. So
The purpose of them is to make people eligible for Medicaid and keep their benefits.
Let's see. Does pre-purchased funeral expenses count as an asset?
No, it's an exempt asset under federal law.
Thank you. Can the third-party special needs trust own a wide variety of assets, or just things that can be liquid assets?
So essentially, a third-party special needs trust can essentially own anything. The only things I generally don't recommend it owns are automobiles in most cases, and that has nothing to do with whether the trust can own it. It's just a liability risk. The person gets into a car accident, there's not enough insurance, the remaining assets in the trust all of a sudden become available. So we generally just don't like trusts owning cars. But other than that, you can pretty much own anything else you want.
Thank you. Should a special needs individual have a will?
I think everyone should have a will.
Yeah.
One thing to consider is if there is no will and there's no beneficiary designations, then if they have a child, money would go to their child. If they don't, it would be their parents. So it's better to make sure what you want to happen. So I would say everyone should have a will.
My answer is if they're over 18, they should have a will.
When the third-party trust spends funds that benefit the disabled individual, is that considered income for SSI purposes?
It's not considered income. The issue is it in-kind support and maintenance for SSI purposes? And it depends on what the third-party trust is spending the funds on. So if the trust is paying for housing, then yes, it's considered in-kind support and maintenance. On the other hand, in a lot of cases, so what? The loss of the 1/3 benefit for SSI versus the cost of actual housing in Connecticut is huge. You know, if you're losing $200 or $300 a month from the SSI benefit, that's not buying you rent in Connecticut at almost any place I know of. Most rental agreements are going to be more. So I'd rather the trust pay $3,000 for rent in some cases and lose a couple $100.
Here's an interesting question. Is a transfer into a first-party special needs trust subject to the look-back for Medicaid?
Yes and no. Yes, it is subject to the look back in that they're going to ask you what you did with it, but it's not something that can be penalized because it's considered exempt.
Let's see. Sorry, I'm having a...
I can read one. So my financial planner has encouraged me to purchase a life insurance policy of $500,000 in lieu of contributing the $15,000 a year to an ABLE account. What are my thoughts? So as a financial planner, I would say it really depends on what is the goal that you're looking to accomplish. Also, it's important to work with somebody who has an understanding of benefits, and you also just know how they're compensated. So for example, if I help an individual open an ABLE account, I'm helping them do that directly. I don't make anything directly. If a financial planner sells a life insurance policy, they're making money. I find life insurance is a very common recommendation. It's a great way to fund a third-party special needs trust tax-free. However, there's many different types and kinds. Generally speaking, I say the cheaper, the better, right? You're not buying it for investments to build value. You're buying it to leave money to fund a trust after something happens to you. So I would suggest, does the advisor, work for an insurance company and they're recommending life insurance for that reason? The one mistake that I really encourage people to avoid is you don't want to spend $10,000 a year on insurance for a few years and then drop it because it's too expensive. You spent all that money for nothing. So it's very important to, whatever you're doing, make sure that it's your plan for the long run. And every situation's different. So those are my thoughts.
I think this will be the last question, then we'll wrap up. So if you collect SSDI, there is no limit to assets in order to keep your benefits. But if you're a beneficiary of a first-party trust, do you lose your benefit eligibility upon receiving that money?
So if you're getting SSDI benefits just because you've received the money, whether it's goes to a first-party trust or not to a first-party trust, it doesn't really matter. You won't lose any benefits because when you're on SSDI, there's no asset limit for the benefits. But a significant amount of people who are getting SSDI are also going to be dually eligible for Medicare and Medicaid. And with Medicaid, there is an asset limit and you can lose the benefits. And the first party trust will prevent the loss of those benefits there. Although in general, we'd rather it go to the third party trust and we don't even have to deal with any of those issues.
So I think we're going to call it here. We will be distributing materials from this to everybody that attended tonight. And I'm assuming that the materials from Steve and Andrew will have contact information so that people can follow up with questions in particular individual situations. I want to thank Steve and Andrew tremendously for tonight. Really well done. Had a nice rhythm to it. I like the way you segmented things up. I also want to say that on June 10th, we will be hosting Commissioner Jordan Sheff for a town hall meeting. And all of you that attended tonight will be receiving invitations to that. We're going to open up the invitation list probably tomorrow, I think. So thank you very, very much. It's been our pleasure, the Arc Connecticut's pleasure, to hold this, and I think a lot of great information was brought to the forefront. Thank you and good evening.
Thank you.
Thank you.